A federal judge says the healthcare law's requirement for everyone to buy health insurance is defective. We'll talk about what else he said and where it leaves the law. This is the CitizenLink Report. I'm Stuart Shepard, along with Tom Minery, our Senior Vice President of Government and Public Policy. Hi, Tom.
Hello, Stuart.
We're both digging through this 78-page decision, trying to figure out what all the judge talked about. In it, he explained why Obamacare is unconstitutional in the judge's view, and along the way made some strong arguments that we're going to be discussing. In short, it comes down to whether the Constitution gives the government the power to make you buy something. Here's how the judge expressed that. The case is not about whether the act is wise or unwise legislation, or whether it will solve or exacerbate the myriad problems in our healthcare system. In fact, it's not really about our healthcare system at all. It is principally about our federalist system, and it raises very important issues regarding the constitutional role of the federal government. Tom, reflect on that. What's he saying?
Well, he's saying something very important. Stuart, this is a monumental case, and I will say this. If viewers want to take a dip into the issue of constitutional freedom, read the decision. You can do it. There are a lot of references to older cases, a lot of footnotes, and so the actual verbiage is not as long as the 78 pages indicate. It's just fascinating. You can see why Congress needs to be able to regulate something called commerce. There's a commerce clause in the Constitution. Before we had the Constitution, we had the Articles of Confederation, a loose amalgam of state activity. They had to agree to do things, but they had too much freedom. New York, right before the Constitution was discussed and signed, New York said, hey, we control our navigable waters. Nobody can sail the rivers of New York without our permission. New Jersey was building its own navy. 5 states had their own currency, money systems. Mm-hmm. And so in the Constitution, 1787, the Founding Fathers said, Congress shall have the right to regulate commerce with foreign nations, between the several states, I like that old term, and with Indian tribes. And that's it. And it always had to do with economic activity. Now what's at stake is the opposite of that. Can someone's inactivity,
your failure to buy health insurance,
right, violate the Commerce Clause? The Obama administration says yes, and the federal court in Florida, as did the federal court in Virginia, says no. So that's basically where we are.
And it all comes down to that. This has to do with, this case was brought by 26 states, represented either by their attorneys general or their governors, 2 private individuals, and small businesses, the National Federation of Independent Businesses. Am I saying it right?
You are. Let me just jump in here. NFIB, the National Federation of Independent Business, got into this case. Small businesses are the engine of economic growth in our country. Small businesses produce most of the jobs. President Obama says we want to create jobs. NFIB says this will kill jobs because the regulation is too onerous. So it's significant that the National Federation of Independent Businesses got into it.
And you were just talking about whether the government, under the Commerce Clause, the federal government, can make us buy something, or the flip of that really is whether they can punish us for not buying something that they demand we buy. And we've talked along the way that the whole healthcare law is designed in such a way that it can't function without that requirement. If it doesn't have everyone participating, number one, it can't afford to operate. Number two, logically it can't, because you would just wait until you get sick, since there's no more pre-existing condition, which they're very happy to tell you right now is one of the first things they put in place, that people would just wait to buy health insurance. Why bother? On the way in the hospital, you'd sign a form and you'd be covered as soon as you got there. Well, the judge dealt with that, and Judge Vinson says the individual mandate is indisputably necessary to the Act's insurance market reforms, which are in turn indisputably necessary to the purpose of the Act. And then he goes on to say, in the final analysis, the Act has been analogized to a finely crafted handcrafted watch, and that seems to fit, he says. It has approximately 450 separate pieces, but one essential piece, the individual mandate, is defective and must be removed. It cannot function as originally designed. And then in his conclusion, where he voids the act, that means he basically throws it out, says it's unconstitutional. He says, because the individual mandate is unconstitutional and not severable, the entire act must be declared void.
Well, yes, and the issue again is whether one's failure to do something by health insurance is commerce. Wait a minute. If Congress can regulate economic activity, how can they regulate inactivity? Mm-hmm. Is that overreach? Well, the federal government says, now just a minute. It's the individual decisions by a lot of people to get in or get out that can on the aggregate, have a big impact on this system. And there is some precedent for the principle of aggregation. In 1942, a farmer named Roscoe Filburn wanted to plant 12 extra acres of wheat beyond the federal government's allotment. The federal government was trying to control the national wheat prices. Yeah. Too much wheat means prices would go down, farmers would be hurt. Roscoe had 12 extra acres. And that became a federal case, and the decision that came out of that says, no, Roscoe's 12 extra acres in aggregate have an impact on the on the system of economic activity that the federal government wants and can regulate.
Right.
And the 26 attorneys general who filed this lawsuit said, oh, wait a minute, at least Roscoe's activity was activity. He planted something.
He was growing something.
Yeah.
Producing something.
Could the government have forced Roscoe to plant 12 acres that he didn't want to plant? Of course not. But inactivity is what is the overreach that is being alleged by the lawsuit filed by the 26 attorneys general and the two individuals and the National Federation of Independent Business. The attorneys general say something else that's very important. They say this: look, we can't afford it. This is a Hobson's choice. You're requiring us to have our people join the system that pays for Medicaid, health care for indigent people, poor people.
Right.
But we can't afford it. Our state budgets already are overextended, and we cannot afford our people to be able to participate at the cost that's required. However, if we exempt our people from our state, then we lose the federal portion of the reimbursement for Medicaid, and so we can't pay for it either way, whether we're in or whether we're out. This is a mess, is what the 26 states are saying.
Especially when it's called the Affordable Care Act. I mean, that's been ironic from the beginning. And where does this leave us? I mean, what happens now? What's on down the road as this progresses?
Well, obviously, this is a very, very significant case. It bears on the president's centerpiece legislation. There was some talk that it will be expedited to, I almost said extradited, expedited to the Supreme Court. I don't know the ins and outs of that, but obviously this is where this case is headed. It's important that two federal courts now have ruled the health care law unconstitutional. Yeah. And in 2014, if this thing goes into effect and you have not participated, there will be a fine that you have to pay every year on your federal income tax return. So this is a very real financial penalty for people if they don't get involved in this, and that's exactly what's at stake, whether the government can compel somebody to buy something.
Now, after writing 78 pages, there's been a lot of discussion in the blogs about the final footnote. And there are a lot of footnotes in decisions like this one, but the very last one, he cites a rather highly placed constitutional scholar from February of 2008 from an appearance on CNN. That constitutional scholar said, if a mandate, and he was referring to healthcare here, if a mandate was the solution, we can try that to solve homelessness by mandating everybody to buy a house. Of course, you may know that constitutional scholar is now President Barack Obama. He said that as a senator on CNN just a few years ago.
Well, that's interesting. That puts it in clear relief. the states are saying they can't afford to have the people buy this. And you can't legislate that a poor person should be able to buy a house to solve this problem. So there's a parallel here. And the reason that this is so significant is that overreach of the Commerce Clause is what activist, left liberal university professors and judges have used to expand the power of the federal government. I remember them alleging, I don't know who the attorney was and what the case was, but there was an argument made that the federal courts have jurisdiction over marriage because of the Commerce Clause.
Yeah.
For example, if the states denied same-sex marriage, that would mean there were fewer marriages. That would mean there would be fewer wedding ceremonies.
Wedding photographers.
Wedding flowers, wedding cakes. That's commerce. And if the states are permitted to avoid same-sex marriage, that would impinge upon commerce. And so the federal government properly should have jurisdiction over that. That's the kind of overreach that has been building over the years. And that's the kind of overreach that has been stopped cold by this federal court decision in Florida if it's upheld.
All right. Well, thank you, Tom, for your insights, and thank you for watching. You can always write to us at mail@citizenlink.com. We enjoy getting your comments, read every one that comes in, whether it's favorable, unfavorable, we don't mind. We appreciate your criticisms as much as your encouragement. We encourage you to pray for our elected officials, and particularly this week for our judges around the country who are weighing matters such as the healthcare law as part of their daily routine. And remember, stand tall and be heard.